we're going to head to Idaho because accused killer Bryan Kohberger is back in court today.
The judge is holding a hearing there in the quadruple murders case to determine what evidence can be included in Bryan Kohberger's trial. These are motions that include the defense wanting to block digital data from Kohberger's Amazon account, showing that he may have been the one to purchase that K-Bar brand knife and knife sheath months before the murders.
And of course, his DNA found on that button of the knife sheath, which was found at the scene. The defense also wants to block testimony of an Idaho State Police Crime Lab manager about the ways the so-called touch DNA can end up on an item.
Let's get you into court for today's hearing. Where we're starting is with the arguments the defense has made to keep out certain terms in this trial that includes murderer, psychopath, and sociopath. Let's watch.
Me to address all three of those. I'll do that then. Your Honor, the motions are brought to the court based on Mr. Kohberger's constitutional rights and the rules of evidence and relevant case law. With regard to the inflammatory evidence, that is requesting that the court issue an order preventing the state from trying its case with an emotional appeal or an excessive use of emotional phrasing or an excessive use of repetitive photographs. Certainly, we understand that there will be photographs that we may not like that come in, testimony that we may not like that will come in, but what we're talking about is an excessive use of emotional appeal. That the examples that we've seen in relevant case law come from State versus Ellington. In that case, the prosecutor repeatedly used a phrase that was inflammatory about the defendant having run over the wife of a witness who was testifying. And that was found to be inflammatory because of the excessive use of that phrase. Additionally, in that case, there was an appeal to juror emotion when the state sought testimony from a witness about why he might have left his job. Those are examples of what we're talking about. The court has to do the rules of evidence balancing test, and to do that after the state has elicited inflammatory testimony is difficult to undo and puts Mr. Kohberger in a position where the jury's already been inflamed. And so we're seeking to prevent that. Your Honor, I will move then to our motion regarding the murder term. This motion is also based in Mr. Kohberger's constitutional rights to due process and to a fair trial. This is not a motion to ask the state not to use the term murder. That's going to come out when the court reads to the jury the charging document. That's going to come out in jury instructions. This motion is about the state, through its witnesses, labeling Mr. Kohberger. That invades the province of the jury. Mr. Kohberger sits here today. He's innocent, and it's up to the state to bring evidence and a jury to decide if that's different. The state, by using that kind of term as applied to Mr. Kohberger, gets in the way of what the jury needs to decide. Back when we were looking at a change of venue in this case, we worked with a social scientist named Dr. Amani El Aleli, and she talked a lot about how bias is made in people and how we think about things and how we remember things. And one of the things she talked about, and her report is in the court record, one of the things she talked about is the influence of people in a position of authority. And for the state to come in and label Mr. Kohberger in their position of authority or ask a witness, especially a witness in uniform, to do so is very detrimental. It's inflammatory to Mr. Kohberger. And it would—
Outside of opening statements, perhaps, where the state might say, we intend to prove the defendant murdered the victims, perhaps in reference in voir dire, that, in this case, the defendant is accused of murder. I'm having a trouble understanding how this would come up during the evidence phase of things.
Your Honor, that's why I'm asking the court to issue an order to prevent it from coming up.
Sounds like you're asking me to issue an order that says the state shall not commit prosecutorial misconduct or the parties will follow the rules of evidence.
Your Honor, I would like an order that the parties will follow the rules of evidence.
I'm sure the state would like one too.
I'm not going to oppose that, Your Honor. We'll get to the state's motion.
I don't think I need an order because, as the name implies, they are rules, which means they will be followed.
Your Honor, in an abundance of caution, we bring these motions, and that's based on review of case law and based on years of experience. When things happen in trial, I found and I believe that it's relevant to bring these kinds of motions before the court now and have all of the parties aware of.
I think there's maybe a difference between bringing them to make sure that the issues are highlighted and the parties are vigilant versus perhaps entering sort of prescriptive orders that are so broad and vague in nature that they are essentially meaningless.
Your Honor, this is my opportunity and the place that is reserved for the defense to bring these motions. I think that they're important motions, and with court's orders, it makes it more clear. Even if the court order isn't spelling out, you can't say this, you can't do that. I think there's an awareness, and I think it's relevant to have that order. I think it's important to have that order. And most of all, I think it's protective of Mr. Kohberger's constitutional rights to have that order. That's our request with regard to
Address sociopath or psychopath. That
Yes,
seemed
I'd like
the
to
state
address.
was intending to go there, but you're welcome to address it.
Your Honor, if the state is stipulating not to use those terms, I don't need to make a full argument on that, but I'm prepared to do so. I'll be brief. Then with that, we brought this motion again under Mr. Kohberger's constitutional rights to a fair trial and due process of law. This motion is really spelled out in Dr. John Eden's affidavit when he talks about the unreliability of tests that might label somebody in that particular way and the danger of having that label applied to somebody. If that's allowed to happen, then Mr. Kohberger is colored with an opinion or a way the jury will view him that is unfair. And our request is that the court not allow the state to label him in testimony as a psychopath or a sociopath, because any kind of testing is unreliable. That would relate to, or that would become problematic within the rules of evidence to do so, and the inflammatory nature of those kinds of labels would.
I'm not aware of any testing that has been done that has reached that conclusion. Am I missing something?
You are not missing anything. There has not been any testing. There has not been any labeling. This, again, is my opportunity to bring a preventative motion to protect Mr. Kohberger's constitutional rights. And that's the purpose of that motion. Thank you.
All right, there's the defense argument there. Don't want murderer, psychopath, brought in sociopath. Don't want the jury to hear that about Bryan Kohberger. Let's bring our guest for the hour. Tanya Bush is with us. She's in Atlanta, civil rights attorney and trial attorney. What's your take on this ask from the defense not to have these terms brought into the trial so that Bryan gets a fair trial?
Well, so when we hear words like psychopath, sociopath, etc., many of us have a preconceived notion. And I think what his attorney is trying to do, and she's done so pretty eloquently, as you can see, the judge asked a very specific question of, there's been no testing done to conclusively state, that the defendant is any one of these labels, right? So I think she is trying to make sure that none of those biases, as she can prevent, some things she cannot stop from coming into the courtroom with jurors, as they've had life experience before they got, into this trial. She's trying to make it so that there are no preconceived notions or biases placed on her client while they are trying to make the determination of, did he actually commit these crimes? So I think she's doing an excellent job of it. I think it's appropriate in this case. What will happen, I don't know what the judge's ruling is going to be on that, but I think we might have a little bit of a hint by the question that he asked, showing that there has been no medical diagnosis of this prior.
Yeah, I think it's an important point that the judge is bringing up. I'm also listening to the prosecution say or not the prosecution rather, but the defense saying there's been no testing. And I wonder if that's global, no testing at all, because they've argued in a filing that he should not be facing the death penalty because of being on the autism spectrum.